Hi, I'm Lindsey McKay, owner of McKay Law. And in this video, I want to explain what happens after you finish your medical treatment. Specifically, how we collect your medical records and bills, and why this stage takes time, but it is absolutely critical to maximizing your case value. The moment you finish treatment, a new phase begins. Once your treatment is complete, your case moves into a new phase called medical records and bills collection. This is the phase where we gather every document needed to prove your damages and present a powerful, well-supported demand to the insurance company. And I want to walk you step by step through how that works. We use a professional third-party records team. We have a dedicated, specialized third-party team whose sole job is requesting medical records, requesting medical bills, obtaining certified versions, tracking responses, following up, and pushing providers for completion. They do this all day, every day. Many law firms wait until the last minute or rely on a single case manager alone. We do not do that. We invest in a specialized team because accurate records mean higher settlements, and where delays happen and why, it's important to understand. We do not control medical providers. We cannot control their response times, their backlog, their staffing, their queue system, their delays, or their internal processes. Every medical provider, hospital, emergency room, imaging center, chiropractor, surgeon, pain management doctor has its own records department, and each has its own rules and timelines. We apply pressure, we follow up repeatedly, and we stay on top of every request, but we cannot control their pace. This is the single most time-consuming stage of the case. Why we request the affidavit forms, the certified version. During treatment, while you are going to the doctor, we collect a working version of your records and bills so that we can track your progress. But after your treatment is complete, we request certified, notarized medical records and bills known as affidavits. Think of it like this. During treatment, we collect copies. After treatment, we collect the official stamped version. The affidavit version is legally verified, is notarized, it is admissible in court, signals to the adjuster that we are prepared to file suit if we have to. It strengthens your negotiation position, prevents the insurance company from dragging their feet. A normal record is like a photocopy. An affidavit is the sealed, authenticated version that holds up in court. Insurance adjusters take affidavit records more seriously because they know we are ready to file suit, we are organized, we are not bluffing. Why this step is a strategic power move. By submitting certified affidavits with your demand package, we send a clear message. We are ready for trial, we are prepared, we know your tactics, insurance company, and we will not be pushed around. When adjusters see that we are already obtained affidavits, they know we are organized, we understand litigation timelines, we can file immediately, we are not a settle fast and cheap firm. Many law firms skip this step. We do not. We do the extra work because it increases your case value and potentially the time frame. The legal deadline, why we do this early. Under Texas law, medical affidavits must be filed within 90 days after the defendant files an answer if your case goes to litigation. Because certification takes time, we start collecting affidavits before the demand goes out. This protects you. It keeps us trial ready. It removes any opportunity for the insurance company to delay. But without affidavits, the adjuster assumes they're not ready, we can drag this out. With affidavits, the adjuster realizes this firm is serious, we need to settle this. This gives you enormous leverage. Once we receive all records in affidavit form, we then review every page. When the certified records and bills arrive, the next step is reading, reviewing all diagnosis, imaging findings, provider narratives, pain complaints, inconsistencies, old injuries, medical notes. Then we redact any private or irrelevant information the insurance company is not entitled to. This is a part of protecting your privacy. Packaging and demand, the art of presenting your case. After we redact and review your medical records, your case enters the packaging phase where we draft your demand letter, prepare a complete medical chronology, calculate total hard damages, make sure your hardship story is included. We summarize key findings. We create your damage presentation, strategically decide what information to include now, what information we want to hold back for negotiation leverage. This is not a copy and paste job. This is a surgical, highly strategic process where we craft your story and present the strongest version of your case. Your medical records are the blueprint of your case. Think of your case like building a house. Your medical records are the architectural blueprints. Without them, nothing is structurally sound. With them, everything becomes clear, organized, and undeniable. We take the time to ensure your blueprint is flawless because your compensation depends on it. The medical records phase might feel slow, but it is one of the most important parts of your case. We use a professional records team, request certified affidavits, follow up relentlessly, protect your privacy, read every page, build a strategic demand package, all so that when we go to the insurance company, your case is undeniable, unshakable, and worthy of full value. I'm Lindsey McKay with McKay Law. Thank you for trusting us. We are doing the heavy lifting to protect your case and maximize your recovery.